Christopher Sunnen is the head of Sunnen Law, a firm that specializes in family law, and its crossover friend, Marvin Actions. I'm dying to know what that means, by the way. With over 20 years of trial experience and as a certified family law specialist, Chris is known for litigating items on both the short set and long set calendars. Chris was selected as the face of divorce law by San Diego Magazine and voted San Diego's best by the San Diego Union Tribune readers. Please help me welcome Christopher Sunnen.
All right, guys, got a lot to do in a short amount of time, so nobody wants to hear about me. If you want to know about me, you can Google me. Don't stalk me. I'll get a restraining order. That's trial practice for you. All right. So, as I think we've heard today, you're going to come see me when everything else has gone south, or you're going to come see Ben. And one of the reasons I like Ben is Ben used an example I was going to use. He read my mind, big Game of Thrones fan. I was listening to Amanda. I thought, we as trial lawyers are forward-thinking, but forward-thinking in a litigation context is more like Game of Thrones. That was the connection I made. Then Ben came up and kind of spoiled it, but that's why I love Ben. All right, so I'd put what you do when all else fails. It's the same thing. It is Game of Thrones. And to bring it back to Amanda, we are forward-thinking, but forward-thinking in litigation is this: trench warfare. I am telling my clients this day in and day out. I will be the one leading the charge. I will fix the bayonet. And then we will gain 3 inches and we'll be in court for 3 years. Amanda knows what I'm talking about. So, one of the things I've been telling people for 20 years is, you don't want to hire me, you want to hire Ben, you want to hire Amanda. You want to resolve this problem at the outset, like Jason was saying. You don't want me. You don't want the guy that's got 20 years of experience. You don't want to pay my fees. Nobody listens. So I'll spell it out and we'll short set this a little bit. The first 2 reasons are the common sense reasons: money and time. You are paying me, you are paying Ben, you are paying us a lot of money. And I guarantee you at one point, you're going to say, why am I paying you this much money, Chris? Why am I paying Ben this much money? Because you can't get along. If you could get along, you would have gone to see Amanda. You would have saved yourself, what, Amanda? Tens of thousands of dollars? Hundreds of thousands of dollars? The sky is the limit. The top question I believe Ben and I get is, how much is this going to cost me? And people hate the answer I give, because I say minimum $435. What is that? That is the filing fee for one person to file divorce. And then I explain that and they go, okay, I can kind of conceptualize that. And then they said, well, how much? How much is this going to cost me? And I say, sky's the limit. And everyone hates that answer. And the reason is it can cost the sky. And so it depends on your budget, but there's no limit. I mean, I worked on cases where it's been millions of dollars of fees. Worked on cases where it's been $5 in fees. You want $5 in fees, you go see Amanda. You want $10 in fees, you go see Ben. You want millions of dollars, you're going to see me. I don't think it's a good idea. I don't think it's a good investment. But nobody listens to me. Nobody listens. So the next top thing is time. Both Ben and Amanda have touched on this. You want to know how long? Let's take a poll. How long do you believe it takes to get a trial in family court in San Diego?
2.5 years.
That's a pretty good guess. Anyone else? No. I tell you right now, if your case is in Chula Vista, and there's a good chunk of cases in Chula Vista, it can take you upwards of 1.5 years just to get a 3-hour hearing. How long do you think it takes to get a multi-day trial? Weeks, years, months. An enormous amount of time. I was in the trial setting department yesterday. You know what the dates they are giving out for 3-day trials? January
2026.
Close, 2025. Money, time. Money, time. You don't want to hire me. You don't want me to go to court. You don't want me leading the charge. But yet, here we are 20 years later. We have an amazing reputation. So, what are some other good reasons not to litigate? Unpredictability. Both Ben and Amanda will tell you, every 3 years, judges get rotated. Sometimes even before then. There's a family law judge recently. He hated family law. He was on the bench for a little over a year. He said, get me out of here. I can't do this. And he got rotated out. Sometimes people get promoted. Sometimes after a year, they get promoted to the Court of Appeal, the Supreme Court, or maybe they go somewhere else. But you have a new judge. Again, as it's been alluded to, you've got somebody who has no idea what's going on in your case, no idea who you are. Some of them don't read. They all tell you they read, but some of them don't. I'm not going to break the news to you. And I'm not being disrespectful. They're very busy. They have heavy calendars. They have a lot going on. But unpredictability. Trifecta right there. And did I say it's very expensive? Oh man, it's very expensive. So, nobody listens to me when I got a slide on this, right? And I say, hey, guys, look at this. Nope, nobody listens. So, let's talk about how it works. Wouldn't it be a fun lawyer presentation about litigation if we didn't have a flow chart? All right, so number one, family court. We have all these fun acronyms, and so I'll break them up. If somebody needs something done in family court, and just so everyone's clear, I'm leaving out all the gory stuff about restraining orders and child custody. We're not even going to go there. We're just talking about financial litigation, and specifically real property litigation. So, number one, somebody's got to file a motion. In family court, it's known as an RFO. RFO equals motion. Step two, the court will give you that hearing date. Your clients, who are you're working with, will tell you, great, we got a date that's 90 days out. You told me it was going to be years. You flipping know nothing. No, that hearing the court gives you is what's known as the 20-minute or the 40-minute calendar. And spoiler alert, the 40-minute calendar can sometimes also just be the 20-minute calendar. And on these calendars, these judges have overset hearings. That means they may not even have 20 minutes for you. So a lot of people watch Law and Order. It's more entertaining than Game of Thrones and less gory. You can treat this RFO hearing that you get in 90 days as what's known as a preliminary hearing. Because what's going to happen is you're going to go in, I'm going to go in, I'm going to say, hey, Judge, nice to see you. They're going to say, Mr. Sunnen, I hate your bald head. And you're back again. And they're going to say, I don't have time, Mr. Sunnen, to deal with the sale of a house. I don't have time, Mr. Sunnen, to characterize this property. Your expert you brought in, Mr. Sunnen, Mr. Gordon, Ms. Potterton, any of these other realtors, they all seem like great people, but they're not here. It's hearsay. We don't have the time to deal with this. If you don't prepare your client for that at the beginning, they're going to leave this hearing shell-shocked. They're going to say, but that was my hearing to sell the house, and it only lasted 10 minutes, and they didn't listen to Mr. Gordon's report or Ms. Potterton's report. That's because the system is not set up that way. What did I say? It takes time and money. And so when you're at this initial hearing, you're going to be looking at something that's probably not going to get decided. So we're now, where are we at? Step 5. So responsible lawyers like myself, we've explained this all to the people you guys are working with. We tell them you're going to need what's known as a 217 hearing. What is that? That's an evidentiary hearing. You guys can say that's a trial, because it is a trial. So, and we're back to that horrible, horrible zone of waiting and waiting. So, what are we mainly litigating when we're filing these motions? This is important to you guys. Characterization of property, valuation of property, disposition of property, and we got this fun other characterization area at the bottom. Reimbursement claims, separate property claims, payments of post-separation utilities, mortgage payments, breach of fiduciary duty claims, calculations, and what Ben was alluding to, violations of the summons, which we lawyers call a fancy term, atros violations. So let's see how we're doing on time. We are doing good. All right. So before, and this is kind of like Monopoly, before we get to disposition of property, which is what you guys are concerned about, selling the property, we have to characterize and value the property, because that's how court works. We don't just go to disposition, which is what you guys would like to do. Makes common sense, right? We got to sell the house? Nope, we got to characterize and value it, because somebody has hired me, which means somebody on the other side has hired someone either equally experienced or more unreasonable, and we're in court. We're not making agreements like Amanda wants to do. We're not making agreements like Jason wants to do. Everyone wants to fight. And what's the top thing we're fighting over? Characterization. And so there's a long section of the law here, and you guys can read it, and I'm happy to provide these slides later to Jason, and I'll get distributed from there. But the court needs to characterize the property. Is it community property? Is it separate property? Is it some combination of the both? Is it something else? This is the first step we have to do. What do we do in a characterization issue? We have to have a trial because this is not being decided in 10 minutes. All that's going on in 10 minutes is me talking really loudly, and then the other lawyer talking really loudly, and then the judge says, both of you stop talking, I'm going to talk even louder, and then that's why we have a trial. Characterization claims. Touched on it a moment ago. We have separate property versus community property. You guys need to know this. There's a presumption under the law, it's Family Code 770, that anything acquired before marriage is separate property. There's an equal presumption that anything acquired during the marriage is community property. It's Family Code 760. This sounds pretty straightforward, right? And yet we're spending 2 days, 3 days, 4 days, 5 days addressing these things. It cannot be simple at times because it's California. We also have in this state the title presumption. It's Evidence Code 662. It's recently been clarified in In Re Brace, which is a great kind of treatise on how the court treats title. Other things we got to watch out for in these characterization claims is what's known as a transmutation. And the law is actually quite clear on this as well. I'll give you an example. Let's say Amanda and I are married, and I had a house before we came into the marriage, and Amanda says after 20 years, I'm really tired of you. You talk loud. You're annoying. And I say, hey, would it make you feel better if I put you on title? And she says, it sure would. That's not good enough. We need an express writing. And so that's what the law requires. But, even though the law says it, there's a lot of variation in litigation about it. So once we characterize the property at a trial, we move on to valuation. Because once we characterize it, we know who owns it. The judge has decided it. And now this is where you guys come into the mix, is we need to value the property, we need to divide it equally. It's Family Code Section 2550. And how do we value things in court? Well, bad lawyers say, hey judge, I got a Zillow estimate for you. Everyone loves Zillow, am I right? And then smart alecky lawyers like me come in and we say, hearsay, hearsay. And the judge goes, yep, he's right, it's hearsay. And so there's a couple cases out there where you can get by with an online appraisal. And that's generally when you have a lawyer who's not paying attention and wants to be disbarred and sued for malpractice. Or maybe you have an agreement like with Amanda and Ben. Everyone says, okay, we'll agree on Zillow. We want to save some money and it's kind of accurate this time. But, it's generally not happening. So the top two items we've got are fair market value, which is you guys, realtors. You guys come in. Courts love fair market value because this is San Diego. Fair market value is usually accurate value. Sometimes we need an appraiser. There are some areas out in the county where there are some wild structures going on. Anyone ever been to Potrero? No, it's pretty weird. Someone's laughing. They've been to Potrero. Alternatively, we can go the other way. We can go to Rancho Santa Fe. So that's how we value things. We then have to decide how are we going to dispose of the property. And so this is also what you guys are concerned about. This is going to happen at trial. And as we just talked about, trial is going to happen 3 to 4 years down the road, if not longer. You want to hire someone like Amanda, Ben, because we can do an MSA, we can reach an agreement, or we can do these things. How do we get around waiting for a trial? Well, we can cite Family Code Section 2108 or 1101. This is usually foreclosure type situations where there is a risk to the property. And so I'll kind of blow through these items at the end. There are these other items. Somebody's in the house, they're paying the mortgage, they want to be reimbursed. Yep, they're going to get reimbursed. Somebody's paying the utilities, they're going to get reimbursed too. Sometimes people don't pay the mortgage. Imagine that. It's a breach of fiduciary duty claim. That's also going to be resolved by the court. And at the very end, what's going to happen at these trials I keep referencing? We want good evidence. We want title documents from you guys with no contradictions. We want clear chain of title. We want oral testimony from experts. Who's an expert? Everyone in this room is an expert. You guys all have expertise. And we want oral testimony from parties. We want also documents or other items that are not in dispute. What do we not want at trial? We don't want things that are in dispute. We don't want title documents that have flaws or are contradicted. We don't want sometimes testimony from our clients. We don't want late expert opinions. You're working with a lawyer, we have deadlines. If you don't meet the deadline, your opinion doesn't come in. And if you don't qualify as an expert, meaning suddenly you don't have a license, you're not an expert. We also don't want hearsay. My friend told me this. Nope, don't want that either. So these are the important things to know about pretrial and trial. I'll let you guys kind of skim through that. And that is it. Did I do this in 15 minutes?
You got 30 seconds to spare, buddy. Look at that.